Okay, we continue now with part 3 on libel. In the first part, we talked about the fact that this is a tort where when actual harm is committed by the media or some other party by publishing a false statement of fact, that there can be a legal action, a civil legal action filed seeking recovery on the basis of libel, also known as defamation. We talked about the first element as being publication, and we talked about some little special rules regarding publishers, republishers, and vendors. The latter group, of course, being those who have no control over something, and the former being where there is control, where a decision is made to publish something. And we talked particularly about how this applies with social media because it's so easy to republish information. The second element, and you'll be pleased to know that the second and the remaining elements go a lot more quickly than publishing, has to do with the fact that what is put out, what is published, must be a statement of fact, and it must be false. As we closed out the last time, we talked about opinion a little bit. We talked about the fact that people can injure others by statements that really are a value judgment. I don't think Bob is a good quarterback, or I think that we need to replace our coach. These tend to make people think less of somebody, so to that extent they are defamatory, but they're also pure opinion. So you see the example on the slide. I think Bob is a lousy club president. That's purely opinion. Opinion is protected by the First Amendment and is not a proper basis for a libel action. To be a basis for a libel action, it has to be an allegation of fact that is not provably true. Bob stole from the club's charity fund, for example, would be a statement of fact. If it's false, it's defamatory. It injures Bob's reputation by pretty much categorizing him or labeling him as a thief, and we don't like thieves in our world. So the third bullet there is for you have a mixture of opinion and fact. I think Bob is a lousy club president because he stole money from the chapter's charity fund. Well, that is libelous if it's not true that Bob stole the money. If it's not provably true that Bob stole money, it's libelous. You can't couch an opinion or pair an opinion in a statement of fact and say, well, that was just opinion. It was not just opinion. There was fact included as well. Fact is a word that's used commonly in a lot of different ways in language, but we need to understand that fact is an objectively provable event or occurrence. Something is a fact or it's not a fact, and there can be proof one way or the other. Okay, there's no such thing as false facts and true facts. Just facts are objectively provable events or occurrences. The score was 42-12. That's objectively provable statement of fact. Fred ran up the score to an unfair level. Unfair is opinion. It's a value judgment, and so it's not actionable. So you have to look to these cases and see if they contain statements of fact. Again, just kind of beating this thing into the ground. Opinion cannot be the basis of libel because you can't prove an opinion. She's smarter than you are. Well, maybe she could take a test or something like that. Opinion can harm reputation, but it's not actionable because it's not fact. Now, libel cases are problematic for a lot of people if you don't boil them down to the nut of it. Was it a false statement of fact? People frequently mix fact and opinion. Bob reminds me of a homeless derelict. Every time I look at him, I want to vomit. He has no business being in our club, much less an officer. Sorry to pick on Bob, but hey, You know, we have to say things that are injurious to reputation, so we have to say bad things about Bob, even though Bob's probably a pretty good guy. Bob reminds me of a homeless derelict. Is that a statement of fact? No, it's a value judgment. It's not objectively provable. You can't get in my brain and see if I'm picturing a homeless derelict every time I see Bob. Same thing with every time I look at him, I want to vomit. These are value judgments, and then they lead to a conclusion. Now, another example, Bob reminds me of a homeless derelict. The stench follows him wherever he goes. Well, here we do have noses and we can smell. And if we say that a stench follows him wherever he goes, are we saying literally that he smells bad? And probably not, because we have, in addition to opinion and fact, we have shades of meaning. And sometimes opinion can sound like a fact, but we don't mean this literally. As a rule, courts will not take a literal meaning or apply a literal meaning to a figurative expression. You know, this sounds sophomoric, but if you say Earl is blind as a bat and Earl sues you for saying or he's blind as a bat, you're not going to have a bat on the witness stand and Earl on the witness stand and give them an eye test and see which one sees better. But there are cases where reasonable people, if a reasonable member of the jury thinks something is meant literally, even though it may have been expressed figuratively, the law will not provide a shield. But those cases are very rare. It's all libel cases. You have to really look at whether there's been a statement of fact. This is a real challenge for the media when you're dealing with a private plaintiff, is that the burden of proof can shift to the defendant. So something is Bob stole from the club is printed. Bob files suit against the media that contained that statement. Well, that's all Bob has to do. It then becomes up to the defendant to prove the truth or the falsity of the statement. So burden of proof, as we'll see, especially in the next segment, is very important in a courtroom. And deciding who has to prove what can make all the difference in a case. There's also a tendency by media practitioners to go with common assumptions, things that everybody believes to be true. Everybody believes so-and-so is whatever, you know. The movie star, somebody sees a statement that he's been married 6 times or something like that, and then that just gets picked up and repeated. Well, eventually, if the movie star says I've been married 5 times, and it's defamatory to say I've been married 6 times, then it is going to be up to the defendant in court, possibly, to prove the existence of 6 previous marriages. Sometimes you can do that. Sometimes it's a little more challenging. Person is either been identified by actual name, or there's enough information to trace that person to an identity, so that when somebody receives this information, they know who they're supposed to think less of specifically. There's a kind of a compartmentalized case where there might be a fictionalized account of something, and you can say, well, we're making up this story about a certain chancellor at a certain university that's known as the Rebels, or something like that, and so you have enough information to whittle down and figure out exactly who the person is talking about. And interestingly, if you want a hard, fast, clear rule, the disclaimer language that some people include, the following is a work of fiction, it bears no resemblance to any person, intended or otherwise, that is completely meaningless if the situation is that somebody reading or consuming this material knows exactly who you're talking about. The fact that you say, I made all this up, doesn't matter. There's a rule that protects media and other publishers from what's called incidental libel, where a statement of fact is printed about one person and more than one person has that name. There's a media report that Bonnie Parker has been arrested for bank robbery. Well, as it happens, there's also a Bonnie Parker who's a librarian at the high school. Just because somebody might confuse the two Bonnie Parkers, that doesn't give the Bonnie Parker librarian standing to have a libel case just because she has the same name as somebody who's been identified in some communication. The fourth element, I told you these went faster than the first one. The fourth element, and it's why we're saying such nasty things about Bonnie and all these Bob and all these other people, is it has to be defamatory, false and defamatory. If a statement is merely false and it doesn't injure the reputation of the person, then it's not going to give rise to libel. If I identify Bob Smith as the coach at the University of Tennessee, and Bob Smith is really the coach at the University of Memphis, that's a mistake, that's an error, that's wrong, that's false. But it doesn't hurt Bob's reputation, really. I mean, some people like one college, some people like another, but what we mean when we say defamatory means holds the person up to ridicule, lowers the esteem in which a person is held, or my fallback position that we can all understand and have since kindergarten is gives you cooties. The way testimony typically works in this situation is that you put a person on the witness stand and say, do you know Bob? Yes. How long have you known Bob? I've known Bob for 10 years. What do you think about Bob? I said, well, I don't really think much of him. He's kind of somebody I don't want to be around anymore. Have you always had that opinion? I said, no, I used to like being around Bob, but then I saw on the internet where he's convicted of child molestation, and so I don't want to be around him anymore. So you have to have that differentiation. You have to have a before, when somebody thought somebody was a good citizen, a good friend, a reliable, nice, okay guy, and then all of a sudden the person has been defamed. The person's reputation has been injured. People think less of that person. They don't want to be around that person. It kind of goes without saying that there are some people who are libel proof. That means that they have a reputation that is so bad that it can't be hurt. One who comes to mind is Charles Manson. There may be plenty of others out there you could say whatever you want to about them, whether it's a false statement of fact. It's not going to injure their reputation because their reputation is already too bad to suffer. It's so bad that it can't suffer further harm. And one other note in this area is that standards change. Society changes. What used to give rise to people thinking less of a person may no longer be true. This sometimes deals with religion, sometimes deals with race. If you're a fan of the English dramas on PBS Masterpiece Theater, they'll refer to people as papists, as a derogatory term, as a papist. And they were Protestants who were saying that the other people were Catholic, and they were saying that to diminish their reputation, to make people think less of them because they were Catholic. And then you fast forward to today, and you go back to like 1996, and the President of the United States at that time, Bill Clinton, signed a law that said that same-gender marriage would never happen in the United States, but now we have that as the law of the land. So not too long ago, publishing the fact that somebody, or an accusation that somebody was gay, could have injured their reputation. Well, today it's no longer deemed to be defamatory. So that just means that standards change over time. What would have given somebody cooties 100 years ago may not give them cooties today. Now, there's two little technical things here that have to do with proof of damages, and they're more a law school thing than they are a this course thing. There are two kinds of libel. One is called libel per se, which means on its face, and that is that if the false statement of fact that the person is criminal, amoral, infected with a loathsome disease, then there's no requirement to prove damages. For instance, if you just report that somebody has leprosy, well, bless their hearts, nobody's going to want to be around them because they think it's highly contagious, okay? So you've given them cooties if they don't have leprosy, and in fact have leprosy. And in the statement of a person's occupation, it's that the person has been suspended, is incompetent, is unlicensed, has been disbarred, or something like that. These things are called libelous on their face. Anybody reading that would know that this is saying something bad about the person. The opposite one is that a person has to know more to understand that it injured the reputation. It doesn't injure the reputation on the face of it. An example would be saying that a NASCAR driver puts nitrogen in his tires. Now, if you told me that, that's fine. I think that okay. I don't know the NASCAR rules, and if putting nitrogen in your tires in NASCAR is illegal, then basically by saying putting nitrogen in your tires is calling you a cheater. But unless I knew that, then my opinion of the person hasn't changed, okay? So that's libel in context, or libel per quod. You have to know more. Calling a person clumsy, that's no problem. Oh, she's clumsy. All right, well, that doesn't give her cooties. That just says she, can't walk and chew gum. And then you find out that the person is a ballerina. And if you call a ballerina clumsy, then you have done something that would injure the reputation. So you have to look sometimes to see if there's something that's just libelous on its face, or you have to look to get more information. The other thing is that the courts will not let you cherry pick an article or content to find words if overall the impression is balanced. They won't let you cherry pick language and pick out words. If you compared somebody to Robin Hood, they wouldn't be able to sue you based on the fact you called him a thief, because the public image of Robin Hood is not that he's a thief, but that he takes from the bad and gives to the good. The reason we care at all about the difference between whether something's libelous on its face or you have to have more information is as I indicated, proof of damages. If it's the former and it's libel per se, then you don't have to have somebody testify that they think less of you, because it's just assumed that if you say somebody's a criminal who's not, somebody has a disease who doesn't, then you have to you can assume that their reputation has been harmed. However, if there's more information that has to be known about the statement, then proving damages will be important. The explicitness is optional. There are situations where you don't have to use the exact words to accuse somebody of doing something that will injure their reputation. The best example would be some gossipy communication Larry's car was at Debbie's house all weekend. Well, what you're really saying is, given, you know, some scandal about this, you're saying that Debbie and Larry, assuming that they're married to other people or in relationships with other people, that they were engaged in adulterous behavior. And you don't say that. You don't accuse them of that in that specific language. But explicitness is optional in a libel case. If the intent of how something is written is to create the implication that that some nefarious activity, some false and defamatory activity was going on that would injure their reputation, then you don't have to be explicit. In the same way, context can cancel libel. You know, a headline can refer to a baseball player as a master thief. And if in the story you read that the guy's leading the league in stolen bases, then, you know, there's no libel, despite the fact that it could be. I mean, this is real world stuff. Courts laugh that kind of stuff away. And again, this is how it goes. You put somebody, especially in a libel for quote, on the stand. Do you know Ed? Do you like him? Did you see what was written about Ed? What was published about Ed? What do you think of Ed now? And if that shows injury to reputation. We've been talking about private citizens as plaintiffs heretofore, and we'll next talk about how business and professions and products can be injured, have their reputation injured as well. Okay? We'll stop there for now.